thank you very much to the Ambedkar King Study Circle for inviting me to give this very short presentation to you this morning. I'm sorry I'm not with you in person, and I'm very grateful to the organisers for making all this tech work at a distance. My name is Dr. Annapurna Waughray. I'm a Professor of Human Rights Law in the UK, and I'm going to give you what I hope is a simple and straightforward sort of overview introduction to an international perspective on caste and the law, and the specific words that came up in preparation for this presentation were about recognition and remedy. So I'm hoping that what I'll say now will be useful to help you sort of place the legal framework, and then there's time for questions and answers afterwards, with not just myself but a number of other people intervening. Okay, Pujit, next slide please. Thank you. So that's a very brief outline of what we'll be looking at. So 3 sections really: caste inequality in the law in India, both pre and post independence; caste in international human rights law; and caste and equality law in the diaspora. And I'll be speaking a little bit about the UK, which is where my primary experience is, but also the US, and I'm sure that you will know more about the US than I do. So the purpose of this slide is simply to make the point that there's been a long legal history of caste inequality in India. So as I've said on this slide, the idea, the sort of post-colonial idea that caste was invented purely by the colonialists is disproved completely by research over the years, both pre and post the colonial era. So we know that caste inequality was shaped very much by colonial rule, but it wasn't invented by the colonialists. So what we have over a very, very long period of time, going back thousands of years, is a situation of economic and social powerlessness maintained by force. We have agrarian slavery, and of course the British were dependent on the revenue from agrarian slavery. So for that reason, slavery was abolished about a decade later in India than it was by the British elsewhere in their domains. We have the concept of purity, pollution, and of course untouchability. We have, and this is a completely sort of condensed introduction, but we have anti-caste movements and leaders going right back to the Bhakti movement up until the pre-independence period. We have Phule, we have Periyar, we have Dr. Ambedkar, and then we have the invention of the scheduled caste. So the scheduled caste in the Government of India Act 1930. On this slide is a very sort of brief outline of the legal framework on caste prior to independence. So we have caste as a legal construct from ancient times, and there are all kinds of treatises and rules and regulations, and I'm sure that you'll all have heard of some of them, but many others making it clear that the legal concept of caste was embedded for millennia, for centuries, if not millennia. During the British India period, we had the period of company rule, we had the development of Anglo-Hindu law, and then particularly importantly, the Cornwallis Code and this idea of caste practice as a religious issue, so somehow outside state or secular law. And I'm using that that word state and secular law in relation to the British, because of course the legal frameworks prior to the arrival of the British were more complicated than that. But with the arrival of the British, we have this idea of state law, and what they wanted to do was to create a state law framework, but very specifically in order to keep control and keep power, they allowed practices related to caste to be sort of consigned to religious and therefore outside the purview of whatever state law was being developed. So during the period of direct British rule, we can see that with the proclamation of Queen Victoria and the separation, if you like, of personal or religious law from state law. We have there's a lot of literature and information about the practices of exclusion and segregation involving religious premises, which are therefore upheld by colonial courts, and obviously they do nothing about the extrajudicial enforcement of caste prerogatives by dominant castes, of which we all know a lot. The point here about the Government of India Act is that it was this idea of the scheduled castes which found its way into the Constitution of India. And as we know, that concept only includes Hindus, Sikhs and Buddhists. It does not include Muslims or Christians. And on the other side of this slide, I've put something about Ambedkar's approach. To my mind, as a lawyer, Ambedkar was one of the most brilliant human rights lawyers ever, really. His analysis of so many different areas of law and his socio-legal perspective was quite extraordinary. So on this half of the slide, I've just sort of jotted down his ideas about the caste system and what needs to change. So he is very keen on legal and policy intervention, political action, as we know. He talks about Hinduism as law, not religion, and he talks about the caste system as a legal system maintained at the point of a bayonet. So his approach was multifaceted, as I've listed there, but at the bottom point, that law is necessary but not sufficient, and that's very important. We have independence in 1947. We have the Constituent Assembly, the interim government. Post 1950 and the Constitution of India, we have got the following situation, the following framework, if you like. Excuse me. So we have the idea of the scheduled caste, as I've mentioned, and this exclusion of Christians and Muslims, as we know, rumbles on as we speak, despite the accepted understanding that caste is a general social characteristic and it's not exclusive only to Hinduism. So we've got the prohibition of discrimination in the Constitution, the abolition of untouchability, but interestingly, no constitutional definition of caste or definition of untouchability, and no provision for the eradication of caste in the Constitution either. So we have legislation which is all there, and some of it is good, but it's not enforced on the ground, as we know. And one of the limits of the law is the reliance on criminal law to deal with discrimination, which is different to countries from which the drafters of the Constitution took some inspiration. So at the moment, we still have no general sort of civil discrimination legislation, Equality Act in India. And as we know, we have insufficient social and cultural change, something that the scholar Balmurali Natarajan in the US has described as a culturalization of caste. In other words, we have a situation where casteism, caste violence, caste discrimination is somehow painted as benign. So we have extreme examples which are considered to be the exception, but the idea that caste is sort of gradually fading away and is not really such a big issue. It's become just part of the culture for those who are able to not be on the receiving end of it, and that's the important point. But this idea of culturalization of caste, I think, is really useful, because it kind of describes how for everyone except those on the receiving end of caste, it becomes something that is not really there, is invisible, is not really an issue, and if it is, it's kind of very small and very benign. So if we move from India now to international human rights law, so the context for this is starting 1945, end of the Second World War. So the UN Charter. We then have the Indian interim government, the Constituent Assembly debates. We have independence from colonial rule in 47 and partition. 1948, we have the Universal Declaration of Human Rights, which will come up in a slide or so. At the same time, literally a few days prior to the adoption of the Universal Declaration, we have the Convention on the Prevention and Punishment of the Crime of Genocide, which of course is it very much in the news at the moment, both in relation now to Gaza, to Palestine, but also in relation to India. 1948, we also see the establishment of the apartheid regime in South Africa. I'm sorry, I put 1948 twice, not quite sure why, and Constitution of India, and all of this in a wider context of the beginning of the decolonization process and the beginning of the Cold War. International human rights law, when we talk about international human rights law, this was developed, as I said, after World War II, and it was anchored in the new United Nations organization created in 1945. The UN Charter isn't primarily a human rights document. It's the main purpose of the Charter and the UN was to maintain international peace and security, and we can see how well that isn't going at the moment. The promotion of human rights was fundamental freedoms was a secondary purpose, but it led to then a whole kind of domino effect of further declarations and eventually legally binding human rights treaties. So the UDHR 1948, it's not a treaty, it's not legally binding, it's a declaration, but it does contain the basic fundamental principle of human rights, so equality before the law and equal protection of the law without discrimination. That's a very important principle found in all the subsequent human rights treaties. So in terms of the UN human rights system, we've got two elements. We have, on the one hand, the human rights treaties, which are legally binding, and on the other hand, we have the UN mechanisms and bodies, what you might call the political side or the soft law, which are not legally binding, and that includes the UDHR, the Minorities Declarations, Special Rapporteur on Minority Issues, and so on. The point about human rights treaties is that they do impose international legal obligations on states, and those treaties are then monitored or enforced by monitoring committees, but there are no compulsory sanctions. So as with all international law, the human rights treaties depend on the will of states, the goodwill, the political will of states to comply with them, to abide by them. There is no superpower that can make a state do something it doesn't want to do. In terms of caste and international human rights law, and this is important because in a second I'm going to show you the thread running through the early engagement with this international regime and the principles of solidarity that we are now very involved in. So in terms of recognition, this is a bit I've taken this from my book, but it was sort of the best way of explaining it. So the main problem with international human rights law and caste is that caste is not a category anywhere. So in order to bring caste within the ambit of international human rights law, we've had to put it somewhere else, which is not caste. And actually the other issue is that right until the mid-1990s, it was something that was really not very well understood or known or heard about outside of South Asia. So I've just jotted down here some early attempts to engage the UN on caste. So some of you may be familiar with this, and apologies if I'm telling you things that you already know. 1946, we've got Ambedkar writing to the African American activist and intellectual W. Du Bois about the petition that the African Americans did present to the UN on racism in 1947. And for Ambedkar, and I'm sure you know this, he was very struck by the similarities between the position of the untouchables, as the word that he used, and the position of blacks in America. And he drafted a similar petition to the UN on behalf of the Scheduled Castes and approved by the Scheduled Caste Federation. But he didn't send it because he was at that point involved in the Constituent Assembly debates, the interim government, and he wanted to give the future Parliament a chance, as he put it, to deal with the matter. So that was why he held back. The next, so that kind of connection is really important, and I think important also from the point of view of activists in the United States. The next thing I just wanted to mention is that in 1946, India secured the first ever UN General Assembly resolution in the new United Nations, and it was a resolution condemning the treatment of Indians in South Africa. And it kind of set the scene for India as the sort of leader in the anti-racist and non-aligned movement. And this was very important to India because of the history of colonialism to be presented in this way. But something very interesting happened, which is that in response, South Africa, the South African representative said, but what about that your discriminatory treatment of and the word that was used, and I took this from Lakshmi Pandit's autobiography. The word that was used was India's treatment of its Harijans, so the Scheduled Castes, and the response that came back was that this was completely irrelevant. And while India was arguing that the treatment of Indians, discrimination on grounds of race and colour, was a moral as well as a legal issue, and that South Africa should abide by the principles of the UN Charter, at the same time, any attempt to say, but what about what's happening in India was very forcefully rebuffed. And I think that's quite revelatory of the way in which the non-Dalit leadership in India at the time was seeing things. Moving from that to the first ever UN Human Rights Treaty, the International Convention on the Elimination of Racial Discrimination, which India ratified, and so has the UK, and so has the US. It didn't contain any mention of caste, but the grounds of discrimination are race, colour, descent, national or ethnic origin. So those are the grounds of discrimination under this international treaty. And as we'll see, doesn't mention caste, but there was a way in which caste was managed to be included in this treaty. So this treaty, the International Convention on Racial Discrimination, ICERD, for the way that these international human rights treaties are monitored is that when a state ratifies, i.e. signs up to be legally bound by the contents of the treaty, they then have to submit a kind of self-audit called a report every 4 years to this monitoring body, and the monitoring body will have a look at the self-audit and say, yes, we see you've done all these great things, but on the other hand, you haven't done this, you haven't done that. Can you pay attention to this particular problem? So India reports to the monitoring body, and it does, in every report in the early days, provide information about affirmative action, reservations for the Scheduled Castes. It's difficult to understand why because there's also the subsequent argument that this treaty doesn't cover caste at all. But it feels like, looking at the documents, it feels like an attempt to show how compliant India is with this treaty as one of the leaders in the anti race discrimination movement. But there is a big question of is caste actually covered by the treaty? So in 1986, India, while it's in conversation with the monitoring committee, says that the situation of the scheduled caste, as the language was a purely internal matter, and that this was being dealt with domestically, and it was not something that was subject to any kind of international oversight. But of course, this wasn't true. So gradually, as we kind of move towards the 1970s and 1980s, the challenge is how to make caste an international issue. The challenge for those in India on the receiving end of this system of oppression, how to make it an international issue. But of course, we run up against the problem that there's no category in international law. We saw the different categories that were available in the race convention, and the one that eventually got sort of picked on really was dissent. And India, by the time it came to 1996, this had already been raised as a possible category for caste, and this is also on the next slide, by Dalit advocacy groups and activists in India, talking to the monitoring committee of the convention and saying, look, you haven't got caste as a category, so how about using dissent? And it's very interesting. We can keep the question in our minds. Why not race or ethnic origins? It was dissent that was the category that was picked on. And India got wind of this and made a sort of a statement saying caste is not included in dissent. In response to which the monitoring committee said, sorry guys, yes, dissent does include caste. It doesn't refer solely to race. A position which India disagreed with then and has disagreed with since, refusing therefore to accept that the International Race Convention applies to caste. What followed in 2002 was a statement issued by the monitoring committee, and they said, and you can see it in blue at the bottom, that discrimination based on descent includes discrimination against members of communities based on forms of social stratification, such as caste and analogous systems of inherited status. And that's the language which is now used at the international level. So caste and analogous systems. What we can learn from this is the importance of advocacy and the role that advocacy and solidarity work played in getting to this position. The reason that the monitoring committee was forced to take this juridical position was because of the work of advocates, NGOs and individual activists in India. And in 2002, when the committee issued this important statement, they specifically said that it was the oral and written testimony that they received from people on the receiving end of caste that was hugely important in convincing them that they should do this. Making a point also that the statement applies to all kinds of descent-based discrimination, not just caste, and not just to India. Nonetheless, India's consistently refused to accept this interpretation of dissent. But nonetheless, again, this has now become the preeminent human rights treaty for caste. So in terms of recognition, this is a major success in recognition, but of limited use for individual victims. So very important in terms of the acknowledgement and recognition and sort of broadening the understanding, broadening the literacy base of caste, but for individuals not so not so directly used. I just wanted to say something here about norm entrepreneurship and transnational caste advocacy, and I can circulate these slides afterwards, but it's really just to make the point that, as you can see from this slide, going right back to the early 80s, you had some very determined and brave and smart advocates, both in India and in the diaspora, going to the UN and raising the issue of caste discrimination, raising the issue of untouchability. This goes back. This is not, in other words, this is not new. What we've got here is a historical thread of using these international mechanisms, and that's really the point I want to make. So you've all heard, I'm sure, of the Durban conference in 2001, and although the Dalit activists were not successful in getting a reference to caste, or indeed to work and dissent, which is the sort of alternative term for caste, nonetheless it massively raised the profile of the issue. I've put in a bullet point the declaration, the resolution on discrimination based on work and dissent, which was adopted by one of these political bodies in the UN. So that was kind of the alternative strand, if you like, to the Race Convention Treaty development of the globalization or the internationalization of caste. It was using this term discrimination based on work and dissent, which was specifically chosen so as not to provoke India from preventing the resolution being adopted. So what we've got then is we see the development of international solidarity and this idea of norm entrepreneurship, which continues in the domestic sphere, including in diaspora countries. And I think that's really important. We can see it so clearly in the United States and in the UK, people pushing to get a change in the law, to get new legislation, to get legal recognition, and that's what is meant by norm entrepreneurship. So I've just put this in as recognition without remedy for the same reasons as the International Human Rights Treaty side of things, which is we have a lot of recognition now of caste and caste discrimination in the UN minority rights mechanisms. But the problem is that there is no compulsory remedial mechanism for the violation of minority rights. And that problem of enforcement is a problem not just unique to caste or unique to human rights, but actually unique to unique to international law as a whole. So the international law system is a horizontal system. There's no international police force. There's no court or person that can make a state do something it doesn't want to do. So for international lawyers, enforcement has always been the sort of Achilles heel of the system, and that's no different when we're talking about the minority rights mechanisms. But on the other hand, we have got a lot of recognition. So, for example, in country guidelines on caste and dissent-based discrimination for all the UN agencies and activities, and could add a very long list there. So that's a quick snapshot of what's going on at the international level. I'm taking the UK first because this is the area that I've been most involved with, literally for the last more than 20 years. So the UK Equality Act, which is the flagship legislation of the previous Labour government, not the one that's in power now, but the previous one that was booted out in 2010. And this piece of legislation brought together loads and loads of small acts and bits of legislation that had been developed since the 1960s, and essentially prohibits discrimination on these 9 grounds, which are called protected characteristics. So we can see what they are there, and we can also see that caste isn't included in these grounds. So what we have from the 1960s onwards in the UK is the reality of caste discrimination and insufficiency of existing law, but no what's the word, sort of UK-wide organisation to address it, not yet. but lots of addressing it on a small scale in sort of in local fields or within particular communities and groups. The key thing here, though, is the importance of law, practically, educationally, symbolically, and we all understand that in whatever field we're talking about. The Labour government reforms equality law and doesn't put caste in as a new protected characteristic. But what does happen as a result of anti-caste organisations and Dalit activists, an agreement for the Labour government agreed at the very last minute to add something into the Equality Act, which was the possibility of caste being added at a future date. So not actually in the Act, but at a future date. But that provision is in there. The original ask of the Dalit organisations was that caste would be a separate, new, completely freestanding protected characteristic. That probably was not ever going to happen, simply because the UK traditionally has been very reluctant to extend discrimination law. So going way back to the 1980s, not interested in adding discrimination, not interested in adding sexual orientation, really keeping a very tight lid on, we have race, we have sex, we have disability, but not really wanting to add anything else. So it was probably unlikely that caste would have been added, but getting this provision where it could be added in the future was hugely important. And that was the result of years and years of campaigning, lobbying and advocacy work. Then what happened was in 2013, Parliament, much to the consternation of the then coalition government between the Labour, Conservatives and the Lib Dems, changed the permission to add caste to a duty. So you've now got the Equality Act with a duty that caste should be added to the protected characteristic of race. In 2010 and again in 2014, there was research done to look at what is the lie of the land with caste discrimination, and particularly in 2014, the mandate, and I was involved in this piece of work, the mandate was, okay, we have a duty to add caste to the concept of race. How should that be done? Okay, moving swiftly on. Not got very much left to go now. What happened in 2015, because caste was not in the legislation, so as a jobbing lawyer, and I kind of include myself in my former life, I was a civil litigator, and as a jobbing lawyer, you're just looking for how can you win for your client. So okay, you've got caste discrimination claim, you haven't got caste in the legislation, what's the next best thing? So in a number of cases, actually, this one I've put on here is the only successful one. What the lawyers tried to do was to say, okay, caste is actually already covered by race, and for reasons to do with how jurisprudence has developed in the UK, race is actually subdivided into 4 different elements. So race, national origins, ethnic origins, and nationality. And lawyers picked on ethnic origins as the most likely box to be able to convince a judge that caste was in. Because the problem is, with these models of discrimination law, which you also have in the United States, you are bound by the boxes that you've got. So what are the grounds of discrimination that you can use? Race, sex, religion, age, disability, whatever it might be. But you can't bring a claim for something that isn't already in the law or doesn't already offer you a box. So the jobbing lawyer is trying to put caste into one of the existing boxes. And in the UK, it has been race, but specifically the ethnic origins limb of race. That was successful in this one case. It hasn't been successful in the other attempts to rely on ethnic origins, but because of this one case, the Conservative government said, okay, this duty that's in the Equality Act, we don't need it anymore. We're actually going to repeal it. Luckily, they didn't before they lost power. But neither has the duty been enacted. So at the moment, the big push is to try to get or persuade the new Labour government, i.e. the Keir Starmer government, to add caste to race. And our recommendation in 2014 was that it should be a separate thing. So you'd have five now. You'd have colour, nationality, national origins, colour, nationality, and ethnic origins, national origins, and caste. That's the idea. Okay, so I've listed here the opposition to adding caste in the Equality Act, both before 2013 and since. And I'm sure that you will all be very familiar with these arguments because they're the same arguments that are being made in the United States. So I just have a quick look at those, but you will recognise those arguments. The Equality and Human Rights Commission of the UK made this statement when the Theresa May's Conservative government announced that it would repeal the duty to add caste to race in 2018. And it made this point, and this point is the case also in the US. So the US has ratified the Race Convention in 1994. It does have an international obligation to provide for legal protection against caste in domestic legislation. That is one of the requirements of the Race Convention, which of course the US has completely ignored because the US is not interested in international law anyway, but the UK has also ignored it. And the EHRC has said that if you don't have caste, you're going to have people wasting time, effort and energy trying first to get caste into one of the existing boxes before you can even move on to look at the merits of the claim, to look at the evidence. This is your preliminary hurdle, which is why it's so important to have the word in the legislation. In the US and Canada, moving on, I've listed what's going on in the United States, which of course you are more than familiar with. And you can see that there's been a lot of activity to get caste added to state legislation. Of course, in the UK, we don't have the same federal system as you, so it's different for us. But there have been big efforts to get caste added and some successes, not California ultimately, but yes, in Seattle City Council and possibly in New York State. In Canada, there's been a policy position on addressing caste by the Ontario Human Rights Commission, and they've made the same point that okay, caste is not in the Human Rights Code, but we recommend that the existing the code can only be changed by legislation. In the meantime, we recommend using any of the existing boxes to bring claims of caste discrimination. So they're encouraging rather than discouraging the use of kind of adjacent, caste, what you could call caste adjacent characteristics to bring claims. And you may be familiar with this decision in the Columbia Human Rights Tribunal, where a claim for caste discrimination was brought on an intersectional basis as a sort of combo of race, religion, ethnic origins, and succeeded because the judge said it's obvious it should be in there somewhere, and it's captured by all of these. This is some of what was said about the California bill and Gavin Newsom, as you know, and his argument was the same as the Conservative government. Interestingly, although he's a Democrat, it was the same argument as the Conservative government in the UK, which is we don't need this. But as in the UK, bringing cases where we don't need this, so we're going to try and use a caste adjacent descriptor hasn't worked, and that would probably be the case in the US as well. Very happy to answer any questions that I can answer, which may not be very many, but thank you very much for letting me talk right at the beginning of your day. Thank you.